Good afternoon and welcome to the Assembly Judiciary Committee for Wednesday, June 8th. Thank you for being here today. We don't yet have enough members. I won't start as a subcommittee unless we have at least one Republican. So we're going to wait for a Republican if the sergeant, I guess the sergeant is out there actively calling members. I will announce that Assemblymember Autumn Burke will be on the committee today as Assemblymember Luis Alejo is absent. And our item number 4, SB 1257, Senator Block has pulled that bill from our agenda today, so it will not be heard. And absent that, we will wait for enough members to start as a subcommittee. All right, we do have a couple members coming in, so we will start as a subcommittee. And we will start with Senator Block, which is our item number 5, SB 1281.
Thank you, Mr. Chair. I'd like to begin by taking the technical amendment on page 7 of the analysis and thank committee staff for their assistance with this. My bill, SB 1281, will require law schools that aren't accredited by the ABA, the American Bar Association, to disclose important information on tuition costs, class size, number of faculty, bar passage data, and employment outcomes from graduates, to disclose this to prospective students on their website. Students who attend non-ABA accredited law schools do so for a number of reasons, including the dramatically lower cost of non-ABA accredited schools. But under current law, students looking to attend these non-ABA accredited schools are provided substantially less information by the schools than their accredited brethren. In order to be informed consumers, prospective law school students should receive the same kind of robust disclosures regardless of what law school they're applying to. For the ABA schools, ABA Standard 509 requires ABA accredited law schools to post important disclosure information on their website, including bar passage rates, tuition cost, class size, grants and scholarships awarded, GPA, LSAT scores, demographic information, curriculum, employment data, attrition rates, faculty information. SB 1281 will require unaccredited schools to post essentially the same information and will allow prospective students to make apples-to-apples comparison among ABA accredited schools and non-ABA accredited schools in California. It will just let these consumers of legal education make a more informed decision. The bill passed out of the Senate with unanimous bipartisan support and is supported by the Association of California Accredited Law Schools, the Center for Public Interest Law, Public Advocates, and the Public Law Center, among others. It has no opposition, and I respectfully ask for your aye vote.
Thank you. Your first witness in support.
None. He's not here.
All right. Thank you. Anyone in the audience would like to weigh in support? Seeing none, is there any opposition? Other than Senator Wachowski. All right, I'll bring it back to the committee. Questions, comments from the committee? All right. Thank you. Senator, you may close.
I appreciate your aye vote.
Thank you. We will take up an amendment.
Yes.
There were
Thank you,
the
Mr.
vote
Chair.
when we have enough. Thank you. So that now, let's see, Senator Glazier is not here. Senator Morlock. That takes us to item number 3, SB 1255.
Thank you, Chairman Stone and Vice Chairman Wagner. This is an honor. This is my first committee on the Assembly side, so it's great to be in front of you, and I would think hazing is appropriate. By background, I'm a certified public accountant and certified financial planner, and also early in my career worked with a credit counseling nonprofit. So I've certainly become well aware of the financial needs of certain families. Also did a lot of forensic work in divorce cases and sort of dropped that when someone called and said, well, you understand you're a divorce expert. And that just sort of didn't resonate very well. But Senate Bill 1255 is currently under California Family Code. In order to establish the date of separation in anticipation of dividing property through divorce proceedings, a couple must demonstrate that they are living separate and apart. In the recent case with regards to marriage of Davis last year, the California Supreme Court ruled that in order to be living separate and apart, a couple must have separate residences. The court's ruling removes the ability for a divorcing couple to continue to co-parent their children in the same house during the divorce proceedings and still keep their finances separate. This forces at least one spouse to find and pay for alternative housing in order to establish a date of separation earlier than the final court order date, at a time when families are trying to closely monitor their spending and transition the family unit through a trying time. Often, one spouse cannot afford to move to a separate residence and can only afford such a move once a divorce is finalized. This bill would remedy this situation, ensuring nobody is forced to either continue in a bad marriage or face being thrown out in the streets. I used to say that marriage is grand and divorce is 50 grand, and it just makes an incredible impact on families that, for whatever reason, need to terminate their marriage. So, Mr. Chair, that is our bill. I could go into more detail, but I think it sort of speaks for itself. I have had no opposition, request an aye vote, and I have 2 witnesses.
Thank you. First witness, please.
Good afternoon, Chairman Stone and other members of the committee. Thank you for having us here today. My name is Avi Levy. I'm a family law attorney, also a certified family law specialist. My practice is located in Los Angeles County. I am the current chair of affirmative and developing legislation for FlexCom, which is the Family Law Executive Committee for the Family Law section of the State Bar of California. What Davis has done is created a requirement that parties basically must live in separate residences. And in practice, this basically requires at least one party to move out of the family residence, whether or not you have children together, in order to establish a date of separation. What the Davis ruling created in practice for practitioners who do this every day is chaos. The family law community went up, raised their hands, and started, the listservs lit up. We held town hall meetings. We had continuing education seminars on what do we do with this new ruling that just seems so harsh. SB 1255 is important legislation, which we believe is designed to remedy the harsh effects caused by the Davis Bright Line Rule. We believe that humans are complex people. They're not widgets. And decisions regarding data separation should recognize the complexity of humans and give judges discretion. With SB 1255, courts get to consider all factors as to whether the parties have separated. Moving out being one of those factors. It's not the threshold indispensable factor, but it's one of them among all the factors that they can look at. It allows separating parties to continue living together, whether it's because they can't afford 2 homes, or whether it's because they want to wait until their child finishes the school year, or whether they want to continue living together to facilitate co-parenting their young children in their tender years, or whether they have to just wait until the time of trial when they figure out what they're going to be left with in terms of assets and debts before they decide to move somewhere else. Another reason is some people just want to wait until their home sells. If we're going to have a divorcing couple and they can't afford to, let's say, buy each other out of the home and the house has to sell, usually that is the biggest marital asset that people have. And they need that equity to move on to a new home or a new life or whatever they're going to do with that. And so penalizing these people with respect to a bright line rule, you're not separated until you move out, and we don't care that you have to wait until the house sells, or that you have kids together that you want to co-parent, or whatever the reason is, just seems unduly harsh, and we urge your aye vote on the bill.
Thank you. Next witness, please.
Yes, good afternoon.
Could you speak into the microphone, please?
Yes, good afternoon. I'm Diane Fetzer. I'm with the Association for Certified Family Law Specialists, and we're a group of 625 members, and all of us support this bill. We believe that it's extremely important legislation. We believe that Senator Morlock is doing an amazing job in bringing it forth to you because we believe that this bill is extremely important to families. The way we practiced before Davis came down is actually exactly the way this bill will leave us practicing again. Before Davis came down, we allowed people to live together in their residence. You would have a couple that would come in and they might have a very small income and they couldn't afford to move out of their home. So they would share one bedroom and the other person would have the other bedroom. And that's how they would survive. They couldn't afford to move out. And it's extremely important for these families, especially these lower income families that can't afford to actually live separate and apart, which is what Davis requires. It requires you to do that. To meet the threshold test of Davis is almost impossible to be living in the same household. I can give you some examples of how, in my practice, Davis has affected it. For example, I have one case right now where an older couple, they're in their retirement age, just getting ready to retire. Husband and wife separate, but they have to live together. They live together for at least 3 months. Husband continues to work, pays substantial monies into retirement because he's trying to build up that retirement. Then they finally move out. Wife now is going to get the benefit of that retirement, even though for all intents and purposes, the parties had separated. Everything else they had separated out. And they were acting as if they were separated. They were dating other people. They were doing other things. But yet, because they were still under the same house, Davis says they weren't separated, and those earnings are community property. In another case, there's a case where the parties were living together because the parties wanted to parent their children together. They go to court, they get an award of attorney's fees. That attorney's fees, husband has to pay wife $200,000. Davis comes down. Husband pays her $200,000 using his earnings. Well, those earnings now, under Davis, are community property. So now does he now owe her an additional $100,000?
I'm going to need you to wrap up.
So I would urge your aye vote on this bill because it actually provides the court with the discretion to be able to look at the totality of the circumstances.
Thank you. Any other support? Seeing none, is there any opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Wagner.
Yeah, a quick comment. First, I want to thank Flexcom for having originally brought the bill to me to carry. I declined because it's not a good bill. Wasn't a good bill when you brought it to me. It's still not, and I'll tell you why. I can imagine those listservs just lit up because I can imagine all the attorneys who are going to be without as much work now that there's a bright line. Now you say the courts get to consider all the factors. Well, we've spent a lot of time in this committee and in this legislature trying to ease the court's burdens because the courts are underfunded and overworked. And Davis helped do that. It gave us a bright line. It said, here's the date of separation. If you want to be divorced, here's the date. Don't burden the courts with considering all kinds of factors. Don't worry about, you're talking about trying to help lower income families. You're making them spend more in attorney's fees now with this bill. And gosh, at least now the homeowners get to date other people while living under the same roof trying to raise their kids, it doesn't come together for me. It's not what this legislature's been trying to do with respect to burdening the courts. It's not the right way for us to encourage the practice of law and put money into to lawyers' pockets. And we strive in this legislature to write clear laws with bright lines. Court did it for us, and now we're going to turn our back on it. That's why I declined the bill and intend to vote against it. I think you guys are on the wrong track here.
Thank you. Other questions, comments from members? All right, seeing none. We still don't have a quorum yet, but Senator, you may close.
Thank you, Mr. Chair. This bill was brought to me by constituents in Orange County, Bruce and Lisa Hughes, and they do a lot of practice in civil cases. And we found out after doing some research that this was a very critical issue up and down the state. I was rather surprised to get some pretty personal letters from couples that were, even lawyers that were divorcing but wanted to stay in the same home to put their kids through college. So with that, this bright line does make things a little more difficult, and we all know that life is complex, and giving some discretion based on the circumstances is advisable, and I encourage and I vote.
Thank you.
Thank you.
We will take a motion when we have a quorum.
Thank you.
All right, that Second quorum. All right, we do have a quorum. If you would call the roll, please.
Stone?
Here.
Wagner?
Here.
Burke? Chow?
Here.
Chu?
Here.
Gallagher?
Here.
Garcia? Holden?
Here.
Mainshine? Ting.
We do have a quorum. And just to let everyone know, item number 4, SB 1257, was pulled from the agenda at the request of the author. We have a number. Sorry, go ahead.
No, I was going to say I'll move the block bill. I didn't mean to.
Go ahead. That's fine. So we do have a motion on SB 1257. I'm sorry, SB 1281, which we heard earlier. Is there a second? We do have a motion and a second. Call the roll.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Burke? Chow?
Aye.
Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia? Holden?
Aye.
Holden, aye. Mainshine? Ting.
That bill is out. We have a number of items on our consent agenda. If anyone would like to move an item. Okay, so we do have a motion. Is there a second on consent? Second. So we know would like to remove an item. If you would call the roll on consent, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Burke? Chow?
Aye.
Chow, aye. Chu?
Aye.
Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia? Holden?
Aye.
Holden, aye. Mainshine? Ting.
So those bills are out. That is SB 875 Gaines, SB 1087 Anderson, SB 1171, which is the Senate Judiciary Bill, SB 1179 Vidak, SB 1284 Hernandez, SB 1342 Mendoza, SB 1431 Morel, SB 1452 Wajkowski, and SCR 94 Pan. Those items are all out. That brings us to item number 6, SGR 15. Senator Glazer. Oh, yeah. Do we have a motion on item 3, SB 1255? There's a motion. Is there a second? And a second. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Nope.
Wagner, no. Burke? Chow?
Aye.
Chow, aye. Chu? Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia? Holden?
Aye.
Holden, aye. Mainshine? Ting.
That bill needs one more, so it is on call. All right. Senator Glazer.
Thank you, Mr. Chairman and members. Thank you for having me here. I'm presenting SJR 15, which calls on Congress to remove the names of elected and military leaders of the Confederacy from all federal public places, including parks, buildings, and roadways. This legislation tracks with my bill that was approved by both houses last year. Unfortunately, too many public places in our nation still honor Confederate leaders who split the country in two as they fought to preserve the institution of slavery. It's been heartening to see that a national conversation about this has led to some public institutions taking down Confederate names, including an elementary school just last month in San Diego. I believe our search for racial harmony could be boosted if Congress were to act on this, to take steps to remove these racially divisive symbols, the names of military and elected leaders of the Confederacy, from all our federal properties. It's my hope that this resolution inspires people to re-examine examples in America of where we honor those who led this Confederacy movement. Thank you. I respectfully ask for an aye vote.
Thank you, Senator. Is there anyone here in support? Seeing none, is there any opposition? Seeing none, bring it back to the committee. Questions, comments? We do have a motion. We have a second. Senator, you may close.
Thank you, Mr. Chair. I would just say in closing that I thought the analysis by your staff was extraordinarily well done, historical, factual, and compelling. I appreciate the work that was put into preparing it. And with that, I'd ask for an aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Burke? Chow?
Aye.
Chow, aye. Chu? Chu, aye. Gallagher?
Aye.
Gallagher, aye. Garcia? Holden?
Aye.
Holden, aye. Mainshine? Ting?
That bill is out.
Thank you, sir. Thank you.
Thank you. Senator Wieckowski, item number 2, SB 1130.
Thank you very much. Good afternoon. SB 1130 just adds county councils to the list of government entities authorized to demand information from an advertiser to substantiate claims of false or misleading advertising. I thought the staff analysis underscored the need for this. County councilors have the authority to sue, as do district attorneys and the attorney general and city attorneys, but somehow they were omitted from this list of people that can request information from the advertising firm. Well, without this authority, they're really stuck with just going into trial. And as the vice chair indicated in a previous bill, we want to lessen the burden that we have on courts, and by obtaining some information that may resolve the assertion of false advertising. I know in Santa Clara we're going to hear from Danny Chu, who's county counsel. There's claims that are made about the products that can test for and identify birth defects within 30 days of conception, or some misrepresentations on the risk of and benefits of diabetic drugs. So we'll turn it over to my witness, Mr. Chu, and ask for an aye vote.
Thank you, Senator. Your first witness, please.
Thank you. Good afternoon, Chairman Stone and other members of the Judiciary Committee. My name is Danny Chu. I'm an Assistant County Counsel with the Santa Clara County Counsel's Office, and I wanted to thank you for the opportunity to speak today. SB 1130 makes minor additions that will reduce the need for litigation. Like the Attorney General, every district attorney, and every city attorney, every county council has the power to bring in action under the false advertising law. But unlike their public counterparts, county councils do not have the authority to ask advertisers to substantiate their advertising claims before filing a lawsuit. As a result, county councils are not as good a position to investigate and evaluate claims. By correcting this minor oversight, SB 1130 puts county councils in the same position as their public counterparts to avoid unnecessary litigation. First, county councils will be in a better position to weed out claims that are not meritorious before filing a lawsuit. Second, county councils will be in a better position to correct false and misleading advertising without the need for litigation. And finally, SB 1130 will also benefit businesses by giving them notice and the opportunity to correct any violations of the false advertising law before incurring the cost of defending against a lawsuit. The County of Santa Clara therefore urges an aye vote in favor of SB 1130. Thank you.
Thank you. Any other witness in support?
Good afternoon, Chair and members. Denisha Boatner with the California State Association of Counties in support.
Thank you. Anyone else in support? Seeing none, opposition.
Thank you, Mr. Chairman, members of the committee. My name is Hal Dassinger. I'm with the Civil Justice Association of California. Your committee analysis points out that this section was adopted in 1972. It has been amended since then, so there's been ample time. It's not clear that it's an oversight, and what I'd like to suggest is that this is a straightforward effort to expand the ability of the county council to operate in this area, and including bringing additional lawsuits under this area, as opposed to correcting an oversight. The analysis also points out that it's not clear how county council proceeds currently. There's some indication that county council does file these actions, but they don't have the ability to make these interrogations. They don't have the ability to demand substantiation from the advertiser, but it's not clear that they can't get that assistance from one of the groups authorized to make those demands. The county DA seems like the most likely, given that they're both affiliated with the same county, but there's also the city attorney or the AG, depending on where the action is taking place. And then third, the analysis points out that my group, the Civil Justice Association, has frequently been in before this committee arguing that businesses ought to be given prior notice of alleged violations and an opportunity to correct those violations if there are any. And we're absolutely not going, we're not reversing our stand on that. If a demand for substantiation to an advertiser will resolve these claims, we're all for it. But what we're saying is the supporters claim that county council can't do that, that the only way they can get that information is to sue, and that seems unlikely. It seems that it would be easier, in addition to faster and cheaper, to just draft a request for substantiation and get the DA to send it. So we think the current law allows for it. What we expect as a result of this bill is not a reduction in unnecessary litigation, although that would be welcome. What we would expect is the same amount of litigation coming from the DA and the city attorney and the AG, and new and additional litigation coming from county councils, some of it with merit and some without. And so I respectfully ask for your no vote.
Thank you. Anyone else in opposition?
With my apologies, Mr. Chair, I'm a late add-on in support. Elizabeth Espinosa here on behalf of the Board of Supervisors in Santa Cruz County, also supporting Senator Wachowski's bill. Thank you.
Thank you. Anyone else in opposition? Late ads for support? In between? Seeing none, I'll bring it back to the committee. Questions? Comments? Mr. Gallagher.
So I see what the intent is here, but to me, coming out of county government, I know our county councils are overloaded with so many different things that they do. So I think adding to the burden is one of the issues that I have with the bill. County councils are doing conservatorships, they're doing CEQA litigation on behalf of counties, they're doing all kinds of things that I know from my own county. What I came up, they're having a hard time keeping up with all those things. And I do think the other issue is that there's already several other government attorneys who are authorized to bring these cases. So to me, I don't think this bill is necessary at this time.
Thank you. Any other? Mr. Chu and then Mr. Chow.
If I could just clarify with the author, there's nothing in this bill that requires county council to do anything, right? We're simply giving county council the option, if they so choose, like any other public attorney, to utilize this tool.
To be absolutely clear, county council have the ability to sue right now. What they don't have the ability to do is legal authority to ask the false advertiser or the accused false advertiser to substantiate. That's the only additional power. They can all sue right now. So the amount of lawsuits, we only believe, we disagree with civil justice, that we believe that some of these county councils will not sue because they'll get the information and they'll say, oh, now I understand. You've substantiated the claim that you have that this is actually truthful.
So given that we're trying to help county councils be able to do their job more effectively, I'm happy to support this, and I'll make the motion that we move this forward.
Thank you. We do have a motion. Is there a second? And a second. Mr. Chow?
Yeah, I was just wondering how the county council is currently handling false advertising cases. First of all, how many of these cases do you handle or do you file? And secondly, how are you getting the information? Do you need to file a lawsuit to get the information?
We currently have 2 false advertising cases that are pending, one against the manufacturers of Vandia, the other against manufacturers of opioids. In order to bring those suits, we do a lot of investigation by ourselves through multiple sources, interviewing witnesses, etc. That investigation process would be relatively facilitated if we had the opportunity to ask for substantiation of claims. I can also say that when I worked for the San Francisco City Attorney's Office, on several occasions we used this process. In one instance, we decided not to file suit based on the information that we received. In another instance, we were able to negotiate a settlement with the other entity as part of the letter. So basically, it's my belief that giving county councils this power will reduce litigation in the end, and that's based on prior experience.
Thank you. Thank you. Other questions, comments from committee members? All right. Senator, you may close.
I ask for an aye vote.
Thank you. So the motion is do pass. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, no. Burke? Chow? Chow, aye. Chu? Chu, aye. Gallagher? No. Gallagher, no. Garcia? Aye. Garcia, aye. Holden? Holden, aye. Mainshine? Ting.
That needs one more, so we will put that bill on call. Let's see. That takes us to item number 7, ACR 176. Ms. Garcia, are you ready to present? Oh, Mr. Garcia, I'm sorry. I didn't see you there. Yeah, we'll take item number 8, AJR 38. Assemblymember Garcia.
Ladies first.
No. Go ahead.
Well, good afternoon, Mr. Chair and members. Today I present to you AJR 38. This measure would urge the United States Congress and the President to support and sign the Correcting Hurtful and Alienating Names in Government Expression Act, also known as CHANGE Act. This resolution is a companion to AB 1850, a bill that we authored, which passed this committee and went through the Assembly on the consent. Without the CHANGE Act, California is unable to finalize its code change since the federal definition of alien remains in the code. Let me just give you some statistics before I close and respectfully ask for your support. California is home to more than 10 million immigrants. 1 of 4 of them are foreign-born. We have close to 20% of small business owners in the United States are immigrants. Small businesses owned by immigrants employed an estimate of 5 million people. And according to the latest estimates, these small businesses generated more than $776 billion annually. Purchasing power of Latinos and Asians, many whom are immigrants, alone will reach $1.5 trillion and $775 billion, respectively, by the end of this year, according to the Immigration Policy Center. So I think that it's quite clear that for many people, the word alien is derogatory and outdated. According to the dictionary, the word alien means an individual differing in nature or character, typically to the point of incompatibility. I don't believe this word belongs in our code, both in state and federal, and does not reflect our community and our state's values. Members, I respectfully ask for your aye vote.
Thank you. We do have a motion and a second. The motion is that this ACR be adopted, or the AJR be adopted. Do you have witnesses in support? Is there anyone who would like to speak in support? Seeing none, is there any opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Garcia, you may close.
Just respectfully ask for your aye vote.
Thank you. So that the AJR be adopted, call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? No. Wagner, no. Burke? Chow? Aye. Chow, aye. Chu? Aye. Chu, aye. Gallagher? Garcia? Aye. Garcia, aye. Holden? Aye. Holden, aye. Mainshine? Ting.
Needs one more. We'll put it on.
Thank you, Mr. Chair. Thank you, members.
Thank you. All right. Ms. Garcia, item number 7, ACR 176.
Good afternoon. The Girl Scouts were founded in 1912 from that first gathering of a small troops of 18 culturally and ethnically diverse girls. Juliet Daisy Gordon Lowe broke the conventions of the time. In reaching across class, cultural, and ethnic boundaries to ensure all girls, including those with so-called disabilities, have a place to grow and develop their leadership skills. Girl Scouts have continued their vision for more than a century. Today, the Girl Scouts is the largest voluntary association for women and girls in the United States. Girl Scouts is the preeminent leadership development organization for girls, with more than 3 million Scouts worldwide and more than 59 million alumni. 2016 marks the 100th anniversary of the Girl Scouts Gold Award, the highest honor presented by the organization to its most exceptional Scouts. I respectfully ask for your aye vote on the ACR 176 to acknowledge the Girl Scouts' contribution for the last century. And on a personal note, I'm a big fan of these young girls' entrepreneurship. We've all bought their cookies at some point, and now you could buy them online. And very inclusive organization. So excited to have the opportunity to hopefully acknowledge him this year.
Thank you. So we do have a motion and a second. Is there anyone who'd like to speak in support? Seeing none, is there any opposition?
I could sell you some for $6 a box. I'll go to my local troop in my district. They taught me a few things.
And Ms. Garcia, I want to thank you for bringing this forward. A very close friend of mine is the CEO of Girl Scouts in Arizona for the state, and so she hopefully is watching or gets wind. I will make sure she knows what we're doing here today, and appreciate that you brought this forward.
Thank you. And I'll take the privilege. We have our Equality Day breakfast on June 22nd, and we will be honoring 30 of the young girls getting their gold award this year. So you're all welcome to join us. Respectfully ask for an aye vote with that.
Any other questions, comments? Seeing none, I'll take that as your close. That's fine. Call the roll, please. The motion is that this be adopted.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Burke? Aye. Burke, aye. Chow? Aye. Chow, aye. Chu? Chu, aye. Gallagher?
He's going to think about
Gallagher, aye. Garcia?
Aye.
Garcia, aye. Holden? Holden, aye. Mainshine? Ting.
That has been adopted here. Thank you.
All right. Mr. Chairman, you're presenting SB 1005 on behalf of Senator Jackson. When you are ready, you may begin.
I am. Thank you, Mr. Vice Chair. Senator Jackson was not able to be here today and asked me to present on her behalf. Members of the committee, SB 1005 is a follow-on to SB 1306 by Senator Leno that updated the family code with respect to marriage equality. And what this bill does is, again, modernize the code to take out the words husband and wife and put in the gender-neutral term of spouse in all of the code sections. Again, modernizing it with our marriage equality updates. SB 1005 will further clarify the rights available to same-sex couples in registered domestic partnerships by adding a section to the general provisions of the California Code stating that each reference to spouse includes a registered domestic partner where appropriate. I do have witnesses in support, and I ask for your aye vote.
Very good. First witness in support.
Good afternoon, Mr. Chair and committee members. Joe Michael for Equality California. We are proud to sponsor this bill. We were also a sponsor on Senator Leno's bill, and just believe that it's very important for the code to reflect marriage equality, including removing gendered references like husband and wife. We'd also like to highlight that the recent amendments make very clear that domestic partners need to be treated the same as spouses. There's been some confusion about that, particularly among folks who are representing themselves. So we think this bill is important for that reason as well, and we respectfully urge your aye vote. Thank you.
Next witness.
Yes, good afternoon. Robert Sumner here on behalf of Attorney General Kamala Harris. I'll be brief. When the Attorney General fought for marriage equality as the state's chief law officer, it really boiled down to the basic principle of dignity. So I believe that it is not only necessary that our code be accurate and conform with the state of law in light of the recent Supreme Court decisions, but also this is a necessary step to revive California's legacy of full inclusivity. So proud to be here in support.
Additional witnesses in support.
Mr. Chair and members, Seth Bramble here on behalf of the California Teachers Association. We do believe that the legal rights and responsibilities of marriage belong to all adults, regardless of gender, regardless of sexual orientation. I urge your aye vote. Thank you.
Thank you. Additional witnesses in support.
Brian Ortiz on behalf of the ACLU of California in support.
Witnesses in opposition. All right. Committee members, the bill has been moved and seconded. Questions or comments? Yes, ma'am.
I just want to be asked I just want to ask. Long election day. I just want to be asked to be added as a co-author and thank all of you for working on this.
Long election day is a terrible excuse. You were unopposed.
She needs some Girl Scout cookies.
Women's caucus, we did great.
We'll pass that request along to Senator Jackson. Thank you.
Anyone want to follow that up? All right. Bill's been moved and seconded. If you'd like to close.
I ask for your aye vote. On
Thank
behalf
you.
of Senator Jackson, thank you.
Thank you. Call the roll.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Burke? Burke, aye. Chow? Chow, aye. Chu? Chu, aye. Gallagher? Garcia? Garcia, aye. Holden? Holden, aye. Mainshine? Ting?
Senator Jackson's bill is out. That brings us to the conclusion of the items that we wanted to hear. We still have 3 items on call. Would you call the absent members? We're going to start with item number 2, SB 1130, Senator Wajkowski.
Votes 5-2. Chair voting aye. Burke? Aye. Burke, aye. Mainshine? Ting?
That bill is out. Item number 3, SB 1255, Senator Morlock. Call the absent members.
5-1. Chair voting aye. Burke? Aye. Burke, aye. Garcia? Aye. Garcia, aye. Mainshine? Ting?
That bill is out.
SB 1255, Gallagher, aye to abstain.
And the last item is AJR 38, our item number 8. Call the absent members, please.
Vote 5-1. Chair voting aye. Burke? Aye. Burke, aye. Mainshine? Ting?
That bill is out. We have done the business for the day. I'm going to be here for the next 5 or so minutes. If members, I think Mr. Ting and Mr. Mainshine are the missing, and Ms. Burke, if you'd like to add on, we will do that now. Okay, well, let's go through consent. Please call the absent members.
Burke? Burke, aye. Garcia? Aye. Garcia, aye. Mainshine, Ting? And then item 5.
Should be item number 5. Yeah. Item number 5, SB 1281, Senator Block.
Burke? Aye. Burke, aye. Garcia? Aye. Garcia, aye. Mainshine, Ting?
Then item number 6, SJR 15 by Senator Glazier.
Burke? Aye. Burke, aye. Garcia? Aye. Garcia, aye. Mainshine, Ting? That's done, so we're just waiting for...
Okay, so we're waiting for Mr. Ting and Mr. Mainshine. Thank you all. We'll still be here for a few minutes for those members to show up. Oh, okay. So SJR 15 to change a vote.
Gallagher? Gallagher, aye to no.
All right, thank you.